Good morning. Happy Thursday. I thought I'd catch everybody up a little bit on my understanding of everything that's going on currently in all the court cases that I am following. As far as the Earl David Worden appeal, once again, the state has asked for an extension. Once again, the court has granted it. The appeal, or the state's opposition to the appeal, is now due on March 7th, so about another month. So that's still in a holding pattern. The next case I'd like to talk about is DeCastro versus Piratini. Actually, it's DeCastro versus Peter, but right now Piratini, Blue Bacon, is the only person actively opposing the lawsuit. There are two, I believe, motions pending in that case. There is one motion to compel that was brought by Piratini's attorney to compel responses to interrogatories, appearance at deposition, response to production of documents, etc. So, on that particular motion, I would suspect that Piratini is going to prevail as far as the court ordering DeCastro to sit for deposition, to provide the responses to interrogatories, etc. As far as the sanctions, I would expect the court not to grant it, or if they do grant the sanctions, for it to be a small amount, smaller than what was asked for. Why do I say that? Because that is my experience as an attorney, sitting in, listening to other people argue their motions and arguing my own motions to compel. The courts are very reluctant to grant monetary sanctions. Now, if DeCastro's behavior was particularly egregious, I don't mean just refusing to answer him or giving spurious answers. I mean like where he started calling Piratini's attorney expletives or something along those lines, threatening violence, things like that, then I could see it more. But it's just a very, the courts just don't issue sanctions often or in large amounts against the first round of motions to compel discovery. If there are going to be multiple rounds, then the court is going to be much more likely to issue sanctions, up to and including issue sanctions or terminating sanctions. But issue sanctions and terminating are about as rare as hen's teeth. The other motion in DeCastro versus Peter that is between DeCastro and Piratini is DeCastro's motion to demur. His demur, it's not a motion, I guess, technically, is DeCastro's demur to Piratini's affirmative defenses. Once again, I think, well, in this particular case, I think DeCastro is going to win again. He didn't exactly do procedurally what he was supposed to do, at least my understanding of the law, but he is a pro per. It is excusable-ish. And the demur is to the exact same affirmative defenses that were originally pled, and the court struck them because they, or yeah, it was a demur and a motion to strike, I think. Well, anyway, the court allowed the demur, but the court allowed Piratini's attorney an opportunity to amend to add the necessary facts. Now, he didn't add necessary facts to most, if not all of them, and some of them don't need facts as far as my consideration, like from what my understanding is. Some of them you don't need exactly to have facts because it is controverted just by the failure to state a claim. Well, that's you don't have any facts to support that. That's just he didn't carry his burden of proof, right? So some don't need facts, but considering the court has already sustained the demur, I don't think that that's going to be so hot for Piratini's attorney. I think that's a loser because the court has already sustained a demur previously on those particular affirmative defenses. So also, Blue Bacon, Piratini, he was so freaking cocky. I love it. So an attorney can be somewhat cocky when saying, go ahead and sue me because I don't need to pay an attorney to represent me. I am competent to represent myself. Thank you very much. And you're going to say, well, an attorney who represents himself has a fool for a client. Well, if I'm dealing with someone like DeCastro, who's going to come bringing nonsense, bringing nothing, where I have nothing to lose, I could play the discovery game all day. I mean, I don't need to hire an attorney to figure out how to do discovery, how to write an answer. It's a bit different. Like if there was a credible lawsuit against me where I actually had something at stake, then I'd get an attorney. But playing fuck around and find out games with DeCastro, who cares, right? But Bacon was so cocky. Sue me, I'm waiting for my lawsuit, DeCastro. I'm waiting for my lawsuit. How are you enjoying spending those attorney fees? How are you enjoying that, Blue Bacon? Is it good? Does it feel good? Does it make you all tingly? Does it make you feel warm and fuzzy inside? Because I guarantee you that attorneys from the LA area, they are pricey. At least in my experience, having dealt with a few of them, they're not inexpensive to retain. There's a high standard, a high cost of living down there, and it's reflected in attorney fees. So enjoy that. You fucking douche. Anyway, so that's DeCastro versus Piratini. DeCastro versus LVMPD. I believe. Well, so if the reply brief by there's a pending motion to dismiss for failure, 12B6 motion / summary judgment motion. It could be either one. It's probably going to be. The court is probably going to adjudicate it as a summary judgment motion. So if the defense representation that the body cam videos, which I have not seen, show no unreasonable force being applied to DeCastro, and if they are complete enough that there's no break where you can't see what's going on, where someone could be punching DeCastro in the nuts, I suspect there is a better than 50-50 chance that the court is going to dismiss the case on summary judgment. Grant judgment in favor of defendants, I should say. But that's a factual and evidentiary issue that I can't really judge. I mean, I can't see the quality of these body cam videos. It's difficult. The arguments that Chili's new attorney made, they're not very convincing. And here's a fun fact for you folks. If you have a civil lawsuit going on where the issues turn on whether or not there was probable cause for an arrest, and you also have a criminal action on the same facts where also the issue would be probable cause, one would assume that where you're facing actual jail time, that your lawyer, who represents you in both, if there was no probable cause, would bring a motion in the criminal action to have it dismissed based on lack of probable cause. What don't we see in the criminal action? That is highly indicative that there was, in fact, probable cause. Chili's own attorney tacitly admits that there's probable cause because he's not bringing a motion in the civil action challenging probable cause for the arrest. It's academic, folks. DeCastro versus Wagner. I strongly suspect that Chili's going to lose the appeal. Since defense requested oral arguments, the opposite, well, I guess technically it'd be the respondent in the appeal, the defense in the underlying lawsuit. Since they requested oral arguments, I suspect there will be oral arguments. I think they will be hilarious, and I can't wait to see them if they in fact happen. If I can actually find them anywhere on the YouTubes, because they'll be amazing and hilarious and awesome. So then finally, is it finally? Yes, finally is Springer versus the 7th Judicial District. Oh, no. Before we move off of DeCastro, I saw in my Discord today that he has been arrested over Valentine's Day. Obstructing and giving false identification to the police, false information to police. I remember in his 5A cop cards, that he has he explained one of them, like, you could identify as whatever you want. So if they ask what you ask for your identification, you could say you identify as, Bob today. But that's not what they're asking. What they're asking for is actually your identification. In Nevada, at least, as we know from Hibble versus the 6th Judicial District Court, I think that's the name of it's Hibble versus the 6th something of Nevada. The Supreme Court looked at, after it went all the way through the state courts, they looked at Nevada's stop and ID law, where if the cops have reasonable suspicion, then they could demand your identification. That doesn't mean your physical identification, but you have to give them your name. You have to give them your name. You have to give them your name. Not what you identify as today, but your name, your legal name, so they can look you up. You have to do that. And I have a sneaking suspicion that Chili tried out his own advice and gave them a false name, because that's what he identified right then. I identify as Bob Smith right now. So I can't wait to see that. If you do the same thing over and over again and you keep getting the same result, but you think you should be getting a different result, maybe the problem is you. Maybe the problem is your understanding. Chili keeps trying this obstruction thing. He never gets the police to stop doing what they're doing. He never gets them to change their tactics. But he seems to have a fairly good track record of getting detained, arrested, ticketed, whatever. I've seen multiple of these now. So it's a pattern. If it's not working for you, Chili, and you keep doing it, that's insanity. You probably should stop. It reminds me of a attorney I worked for. He liked to do depositions. He loves depositions. Depositions are great. You put on a show for your client. The other side basically has to answer your question. Opposing counsel can make objections, but they can't really do anything to stop you from asking the questions and getting the answers, unless they assert a privilege, in which case, yeah. But it makes you look like you're the tough guy and you're in control. It's great client theater. Great client theater. Not always useful. In some situations they are. Not always useful. But great client theater. Clients love it. They eat it up. They're like, oh my gosh, you just wrecked that other attorney in there. Oh, you just showed it. Oh. Anyway, so he loves depositions. And twice we had cases that were DVs come in. And twice he wanted to depose the protected party, i.e. the person who had a temporary restraining order against him. Now, in a DV action, generally speaking, there is no right to discovery. That's my understanding. And not only did he want to have the DV, and in both cases, opposing counsel was like, I'll allow the DV, or I'll allow the deposition, but your client can't be present. But my boss at the time wanted the client to be present, because it's client theater. He wants the client there to see what he's doing, because it's not really trying to get information. That's not really the purpose of it. The purpose of it is to generate billing and to give the client the feel-good feeling that you're fighting for the client and that you're the tough guy and that you're in control, blah, 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 right? Keep the client paying. Twice we went to court on it. Twice we lost. Twice we petitioned for a writ of mandate or writ of prohibition, whichever one. We asked for both in our petitions for writ. Relying on the same case. It's Willoughby something. I forget the name of it, where the Court of Appeal in that case said that parties have an absolute right to be present at a deposition. They can't be excluded. Absolute right. Now, it wasn't dealing with a DV case where there was a restraining order in place. But it says absolute right, and one would interpret absolute to be absolute, but that's not the way the court saw it. And that's not the way the Court of Appeal saw it, because twice the petitions for writ were denied without opinion. So what did we do? We stopped trying to do that course of action. Now, that attorney still tries to depose protected parties in DVs, but if the other attorney puts up too much of a stink, he won't have the client present, and we don't petition for writ. We don't file for a motion to compel to allow the protected party to be present. So twice And that client and I, because I interpreted Willoughby to be an absolute right, because that's what it said, absolute. So you learn from your mistakes. And if you don't learn from your mistakes, there's a problem. Speaking of learning from mistakes, we're going to move on now to Springer versus the 7th Judicial District Court of New Mexico. James Freeman, your attorney sucks shit. He is a terrible fucking attorney. I have seen nothing from him in this case that would lead me to believe anything other than he is a shit attorney. Or maybe he's a great attorney, but he's using really shitty underlings to do the work. Or they're not putting in the time and effort or something, because his end product is shit. Judge him by his end product. At the beginning of this, if you watch the very first video where I very first covered this whole thing, I was like, holy shit. If the allegations made in this are true, Springer's got a great case. And this attorney has done nothing but fuck it up with half-ass pleadings the whole time. The current situation in the case is the motion to dismiss was granted for the most part. All the parties, the court found that all the parties except for one were not served. They had not received service of process. The court quashed the service on them because it was ineffective. It did not comply with the federal rules of civil procedure or with New Mexico's rules on how service has to be performed. The attorney who was licensed to practice in that federal circuit and in the state of New Mexico fucked up something as basic as service. And instead of making sure service was done right, he tried shit arguments to convince a court. Like, I don't understand why he would have done this, but he tried shit arguments to convince a court that you could just, as long as the other side gets noticed somehow, it's fine. There's service. No, it doesn't work that way. You have to have proper service. The one party that was served, Susan Rosendahl, the court found that there was no grounds stated for her to be held liable on the two causes of action that the court could discern that she may have some liability in. That the court could interpret these really shit pleadings as alleging a cause of action against Susan Rosendahl. The pleadings, the complaint was so terrible that the court had to try to figure out which ones of the causes of actions may apply to this person and rule her out based on, well, she wasn't mentioned in cause of action number 1, so she can't be a defendant as to cause of action number 1. So it must be cause of action 2 and 3, can't be 4 because that's solely against the 7th Judicial District Court itself. So maybe 2 and 3, but you don't really state like facts that lead me to that could be used to support any sort of judgment against her. You don't state anything specific enough, so I'm going to dismiss it against her without prejudice. I'm going to give you another do-over because you're this fucking terrible at your goddamn job. Here's another do-over. This is going to be your second amended complaint. Third time's the charm. Yeah. Like, James, like, what the fuck is your problem, dude? Like, your attorney's shit. Your attorney is shit. Maybe he's not shit, but he's doing a terrible job for you. If you're paying him by the hour, you're not getting your money's worth. If he's on contingency, well, I don't fucking know how he's going to be on contingency. And I guess technically he's asking for money from the 7th Judicial District Court, but I mean, good God. Good God. He only has state law causes of action against the 7th Judicial District Court. Even if service against them wasn't quashed, why wouldn't they sever? Because the only cause of action that mentions them is the last cause of action. So why wouldn't they move to bifurcate and remand back to state court? Why wouldn't they do that? Anyway, so the motion to dismiss was essentially granted. Service was quashed against all the parties except for Susan Rosendahl. So he gets to try to serve them, and then as far as her, they were dismissed without prejudice. So he gets to file an amended complaint And then his motion for reconsideration for preliminary injunction, that was denied because, well, you don't have service on any of the fucking parties, you idiot. And the one party you did have service on was dismissed. So what are you going to do? Jesus H. Christ. Jesus H. Christ. Are you going to appeal that? That is just such terrible lawyering going on there. I don't know what's in the water in New Mexico, but none of the lawyers in that case impressed me. Going back to Las Vegas, that Craig Anderson guy, the lead attorney for the defense, he's never impressed me. But the reply brief was really strong, and he had that his underling in on that one. His underling does a good job. That's the guy who wrote it, and Anderson just signed off on it, I guess. But the underling does a good job. Props to that guy. He's finally doing a good job. Anyway, that's all I got for you today. Sorry it's such a long video. Thanks for watching. Have a great day.